This is the audio recording for the Torts negligence outline. Negligence is when the defendant breaches a duty of care owed to the plaintiff, causing the plaintiff's damages. The elements of negligence are 1. Duty, 2. Breach, 3. Causation, 4. Damages. Here, the defendant may be held liable for negligence if he breached the duty of care owed to the plaintiff, causing the plaintiff damages, but it must first be established that the defendant owed a duty of care to the plaintiff, so duty must be analyzed as follows. Duty. Duty is comprised of the standard of care and foreseeability of the plaintiff. Duty and the standard of care. Under the general duty doctrine, everyone has a duty not to create an unreasonable risk of harm to others. The applicable standard under the general duty doctrine is the reasonable, prudent person standard, RPP, where the defendant's conduct will be compared to that of an RPP in similar circumstances. As well, a special duty doctrine may apply to the defendant based upon the defendant's relationship with the plaintiff, or where the defendant's conduct creates a known risk of harm to others. General duty, reasonable, prudent person standard. Compare the defendant's conduct to that of an RPP under similar circumstances. Argue RPP standard in every situation, even if the special duty doctrine clearly applies. A reasonable, prudent person is always careful and will have the same physical characteristics as the plaintiff. A person of average intelligence, but the defendant may be held to a higher standard where the defendant possesses greater knowledge or level of expertise than that of the average person. Possesses knowledge of an average community member without consideration of the defendant's actual knowledge. No special consideration is given to mental illness, deficiencies, or sensitivities unless known and targeted. Must know one's own physical handicaps and exercise the care of a person with limitations. E.g., blind people know they can never fly an airplane. Take into account the defendant's physical characteristics and associated impairments, including height, weight, vision, hearing, loss of limb, etc. Voluntary intoxication is not a factor in determining what an RPP would do. Special duty doctrine standards. Under common law, there is no duty to act or rescue a stranger in peril unless statute applies. There is a status relationship. They have a contract. The rescuer voluntarily assumes the duty or places the plaintiff in peril. Rescuer. If defendant acts, they must act as a reasonable, prudent rescuer or would be liable for causing more harm to the plaintiff. Police, firefighter rules. Firefighters and police officers never recover for injuries due to undisclosed risks by the landowner occupier. Standard of care involving children under 4 do not have the capacity to be negligent. Anyone over 4 consider the child's equivalent age, education, intelligence, and experience. Primary exception is when a child is performing adult or dangerous activities. Higher standard of care for medical special duty. Failure to disclose. The defendant physician must disclose personal, research, or economic interests unrelated to the patient's health that may affect the physician's professional judgment, and 2, a physician's failure to disclose such interests may give rise to a cause of action for performing or medical procedures without informed consent or breach of fiduciary duty. Note, states may apply the reasonable physician test or the reasonable patient test. Professional conduct standards for businesses. This applies to common carriers, shopkeepers, innkeepers, grocery stores, restaurants, housing and apartment complexes. Professional conduct standards for industry, including railroads, construction, mining, and road building. Professional standard of care for individual professionals. Business and industry custom or usage may be used to establish a standard of care, but may only be an inference of negligence. It does not control whether certain conduct amounted to negligence. Although certain behavior is customary in an industry, a court may find that the entire industry is acting negligently. Risk analysis doctrine. Under the risk analysis doctrine, if defendant's conduct creates a known risk of harm to others, the greater the risk, the greater the defendant's duty will be to minimize the risk. Scenarios are usually business/industry related, requiring BPL breach analysis discussed below. Landowner occupiers of land. Under the landowner occupier doctrine, depending on the plaintiff's status, the owner occupier must protect, prevent, or warn against an unreasonable risk of harm caused by artificial activities or unreasonably dangerous natural conditions on the land. Trespasser. No duty to undiscovered or unanticipated trespassers, but must be reasonable care to protect from harm by warning of unobvious, concealed, or artificial conditions that could cause death or great bodily injury, and warning must be adequate for a trespasser or reasonable prudence to understand. A discovered trespasser becomes a licensee, and permitted trespasser becomes an invitee. Licensee. Social guests enters on land with permission for the guest's own benefit. Duty owed by owner-occupier is reasonable prudence under the circumstances. Must warn of known, concealed, not obvious conditions that could cause harm. No duty to make safe or to inspect and prevent. Invitee. People that enter on land to conduct business because they are invited to do so. Duty owed by the owner-occupier is reasonable prudence under the circumstances. Duty to protect invitee from all known conditions concealed from invitee. Duty to make safe and duty to conduct a reasonable inspection to discover and prevent unsafe conditions by removing and making obvious. Please note, invitee loses status if exceeds the scope of invitation, converts to discovered trespasser. A discovered trespasser is a licensee. Slip hazard cases. Plaintiff bears the burden of proving that dangerous conditions existed for a sufficient time to support the finding that the defendant had constructive notice of hazardous condition. If the plaintiff can show inspection was not made within a particular period of time prior to the accident, they may raise an inference that the condition existed long enough for the owner to have discovered it. A question of fact exists whether, under all circumstances, the defective condition existed long to be discovered and remedied by an owner in the exercise of reasonable care. Open and obvious doctrine. Defense for premise liability cases. Possessor owes a duty to warn licensee or to exercise reasonable care to protect an invitee from an unreasonable risk caused by a dangerous condition unless the open and obvious nature of the dangerous condition serves as a warning that the person is expected to recognize the potential danger and to protect himself against it. The test is whether a reasonable person under similar circumstances would foresee the danger. Attractive nuisance doctrine. Under the attractive nuisance doctrine, the plaintiff has to show 1. That there is a dangerous artificial condition that the owner knows or should be aware of. 2. The owner knows or should know that children frequent the vicinity of the artificial condition. 3. Condition is likely to cause injury because a child is unable to appreciate the risk of injury. And 4. The extent of remedying the situation is slight compared to the magnitude of the risk. Note, child does not have to be drawn into the land by the artificial condition. Professional standard of care for individual professionals. Courts recognize that one who engages in business, occupation, or profession must exercise the requisite degree of learning, skill, or ability of that calling with reasonable and ordinary care, must act as a member of the profession in good standing within their community world by using knowledge commonly possessed by others in the profession. This includes pilots, architects, and engineers. Doctors. Medical malpractice. Proof of negligence in medical malpractice cases. A licensed physician is presumed to possess the degree of skill and learning possessed by others in the medical profession in good standing within the community of practice and is required to apply that skill and learning with reasonable care. A doctor has committed malpractice if he does not possess or apply the requisite skill and learning. Must do something in treating the plaintiff which the recognized standard of medical malpractice in the community forbids or must have neglected to do what it requires. Standard of medical practice in the community must be shown by evidence. A jury may not be permitted to speculate as to the standard or deviation thereof. No presumption of negligence for want of skill arises from the mere fact that a treatment was unsuccessful, failed to bring the best results, or the patient died. Negligence by reason of departure from the proper standard of practice must be established by expert testimony unless it is evident or grossly apparent to the layman. Other physicians testifying that they would have followed a different course of treatment than applied by the defendant is not sufficient to establish malpractice unless it also appears that the treatment deviated from the standard methods. Less common minority view based on statute and not modernly upheld. Automobile driver to passengers in a car, assumption of duty by acting, emergency situations, duty and foreseeability of the plaintiff. The majority Cardoza view says that only plaintiffs within the zone of danger are foreseeable, but the minority Andrews view says all plaintiffs are foreseeable. Always argue both views. That ends the audio tape outline for negligence.